Okay, Kimberly, wait, record.
This is case number 19001-701NF, Haza Thorpe versus Homeowners Insurance Company.
Good morning, council. Appearances for the record.
Good morning, Your Honor. Brian King on behalf of defendant homeowners.
Mr. Masson, you're still on mute.
Sorry about that, Your Honor. Randall Masson appearing on behalf of Tasia Thorpe.
Okay. Mr. King, this is homeowners motion. You may proceed.
Yes, thank you, Your Honor. This is our second motion to dismiss in this case. This case is a PIP claim that was filed by plaintiff as a result of a March 10, 2018 auto accident. The main crux of this case is attendant care and replacement services. There's also a claim for medical bills. But the crux of this motion is really the attendant care and replacement services claim. And the history of this motion dates back to when I first got in the case. I sent initial discovery request to plaintiff asking that they produce all of their documentation to support these claims for attendant care and replacement services. I didn't receive any response. I was forced to file a motion to compel. They finally answered, and in response to my initial discovery request, they simply attached a copy of our claim file, which obviously is documents that I already had. We proceeded to the plaintiff's deposition in October of last year. She had testified that she was still receiving these services and that her care providers, to her knowledge, were keeping track of what these services were on these, the standard household services and attendant care claim forms. I filed another motion to compel after receiving that testimony. And on November 13, 2019, this court entered an order requiring plaintiff to produce all of the attendant care and replacement services calendars through that date by December 2nd of 2019. And it's important to note that to that point, I had only received the attendant care and replacement service calendars for the date of the accident through November of 2018. So I had from March of 2018 through November of 2018, and this motion was filed in November of 2019. And to that point, I hadn't received any calendars for the year of 2019, even though plaintiff had come to her deposition and testified that these documents existed. So plaintiff was under a court order to produce these by December 2nd of 2019. And that date is important because I had noticed the depositions of all of the care providers to start on December 3rd of 2019. And obviously these documents would be very important to those depositions. They were never produced. I was forced to proceed with those depositions. After those depositions proceeded, I filed a motion to dismiss. That motion to dismiss was filed back in January of 2019. And the court denied our motion, and there was a representation from plaintiff counsel that, well, these documents might not exist, we might not have them. The motion was denied. We then deposed another care provider named Sean Boyer. And that's what's a little confusing in this case is there's 5 different care providers. Mr. Boyer testified at his deposition back in December that he had kept these documents. He did not bring them to his deposition, so we reserved the right to depose him again. We recently deposed him, and he testified under oath that he kept all of these documents throughout the year of 2019 and turned them into plaintiff counsel sometime in January of 2019. So, I'm sorry, January of 2020. So plaintiff counsel has had these documents, according to Mr. Boyer, since January of 2020. I filed my motion to dismiss back in January of 2020, and the documents were never produced in response to that motion, and they were just produced yesterday at 4:30. So I have now had to proceed with this case for a year and a half, requesting these documents that were just produced yesterday. I've been forced to depose all these care providers. Plaintiff has been in violation of this court's order since December 2nd of 2019. We're going on almost 8 months now that they've been in violation of this order. And according to Mr. Boyer, they've had these documents for the last 6 months. And as our motion points out, really, this is the second motion to dismiss. It's the 4th motion to compel I've had to file in this case. 4th discovery motion, excuse me. And there's certain factors that the court can look to when dismissing a case for discovery violations. And I laid them out on page 11 of our brief. It's clear that this has been a willful violation. They've had these documents for quite some time. They just turned them over yesterday. We have case evaluation on Monday, Judge. So I now have documents that I received yesterday with case evaluation proceeding on Monday. There's a clear history of not complying with the court's orders. As I said, this is the fourth discovery motion. They've been in violation of this order for going on 8 months. I think the prejudice is certainly clear, given that we have case evaluation on Monday, and I was forced to proceed with deposing all these individuals without the benefit of these documents that clearly existed. There was a deliberate delay. Again, they've had these documents for months. And there was really no attempt by plaintiff counsel to cure any of this stuff. I had sent emails over the last couple of months asking, are you sure you don't have to supplement discovery? Are you sure you don't have these documents? And I didn't receive anything until yesterday. So I would ask that the court dismiss the case for this discovery violation, the prejudice that it's placed the defendant in defending this case. And I think to the extent the court wants to consider a lesser sanction, which is one of the factors, I would submit that the only lesser sanction would be to just dismiss the attendant care and replacement services claims.
Well, as far as what Mr. Boyer testified to, we provided everything that he gave us when he dropped that off. Whether it included everything that Mr. King expected to receive or not, I can't say for certain. Perhaps Mr. Boyer was mistaken in his answers to his questions, or I hate to say this, but maybe lying. But regardless, we have provided everything that we have any possession of, and I can't explain Mr. Boyer's testimony because I was not present actually for that deposition. We have provided Mr. King with everything that we have available to us, and we have continually applied pressure to our client to provide us with more.
Okay.
The idea that,
excuse me, what was it that you presented yesterday?
I know that we got a bunch of stuff from Viatrol Thorpe the day before, yesterday, and we submitted it as soon as we had it.
So, Mr. King, exactly what did you get yesterday?
I received all of the attendant care and replacement services forms for the year of 2019, which is exactly what I've been requesting since November of 2019, in which they were under court order to produce by December 2nd of 2019.
Mr. Madison, what took you so long to get him those documents? And we've had two motions. He's previously had a motion.
We understand what you're saying, and I put pressure on my client from minute one after the first motion to dismiss, and she kept telling us that we had them. We delivered these things to you months ago, frankly getting angry with us about it. And I have no reason to deny Mr. King what anything that we would have had in our possession that he requested. It has not been a wanton refusal to do anything, and that's a fact. They were under the impression that we had them. We kept telling them we don't. Finally, they just gave up and said they were reproducing them. Because the stuff that I gave him in response to his last motion to dismiss was exactly what Mr. Boyer gave us. So Mr. Boyer was either under the mistaken impression that he had given us everything, or was or was mistaken in his testimony at the deposition. We have at no point attempted to hide anything from him. I do apologize for whatever stress that this delay has caused him, but I think it would be a gross I don't know how to put this. It would be extreme to dismiss this entire case on the basis of this.
And Judge, one additional note here. These documents from Viatrol Thorpe, again, I had been asking for these 2019 calendars since November of 2019 because these were important to depose these people. I had to depose all these people based on the documents I had, which obviously were not these. And I was just produced these yesterday. And in terms of a history of noncompliance, this is not the only court order that they've been in violation of. Your Honor dismissed a portion of their claims due to the 1-year back rule. back in February, I believe, of 2020. And part of that order was for plaintiff counsel to pay $1,000 in attorney's fees, which I still have not received despite my repeated request for that payment. So this is not the only court order that this plaintiff is in violation of.
Mr. Mattson?
Well, I had repeated discussions with Mr. King regarding the $1,000, and he was going to work that into some sort of a settlement arrangement, and that never came into fruition either. We will be happy to take care of that if that's what's necessary.
Right, because at this point in time, I'm prepared to adjourn Caseyville to 30 days, and then you have to be responsible for the adjournment fees. You know, Mr. King has to have that $1,000 within 7 days, and I'll adjourn Caseyville for 30 days, and whatever attendant care forms are not in its possession to date will be barred. So whatever if you're trying to say there's something else, it's not going in.
I
Well,
understand.
Mr.
Judge, the adjournment of Caseyville, I mean, to this point, we've done all the discovery we can. And, I short of redeposing all these people, an adjournment of Caseyville, the prejudice has already happened in this case, Judge. I was already forced to conduct all this discovery and prepare this case without the benefit of these documents. And the documents were submitted 8 months late. So the prejudice has already occurred, Judge.
But it's extreme to dismiss them. So if you can come up with an alternative, let me know, Mr. King.
Well, if the court, look, I understand the court not wanting to dismiss the entire claim, but at least in regards to the attendant care and replacement services forms that were not provided. So for the year of 2019, I think those claims should certainly be dismissed because I had no record of any claims from that time period up until yesterday.
And as Mr. King pointed out, he had an opportunity to depose each of those care providers, and he could have extracted that information during a deposition with or without those documents.
If you recall, Mr. King, what was the nature of the care providers' statements regarding what they provided during that period of time?
Well, and that's part of what the issue was. It was difficult to figure out who was still providing the care. I believe in 2019, the care was only provided by Vietrell Thorpe and Sean Boyer, who are plaintiff's mother and brother. And they had testified that they had filled out these documents, but they were never produced.
But did they talk about what they did?
They did. I mean, they testified to what they could remember generally, but without the documents, I mean, they have no recollection. They don't have an independent recollection of doing these services on each and every day. So, it was more of general questions and I have specific questions about specific days based on what I know plaintiff was doing on these certain days that I could not ask them because the calendars were not produced.
But that's what I'm saying. I understand, but you have them now. The question becomes, do you want to redepose them? Because like I said, I can adjourn Caseyville. You have them. I usually, if they're presented before the hearing, then I usually, like I said, dismissal is a harsh remedy at this point. And I understand that what you're saying in terms of 8 months, and I'm willing to give you some additional time. Let me see here. Let me open this back up. Give me a second. Wait, let me see. I'm going to open this case. Let me open the case up, see where we are. what I'm prepared to do, Mr. King, is give you another $1,000 in cost. That's $2,000 in cost. And that has to be paid, within 14 days, Mr. Mattson.
Okay.
And additionally, um, Mr. King gets to redepose, and those have to be done within 14 days relative to the forms that he received.
The only thing I would point out as far as that goes, and we may need the court's assistance on this, is that Mr. Boyer is currently incarcerated in prison. And that made it extraordinarily difficult for Mr. King to schedule anything. I think 14 days might be a little bit ambitious as far as that goes.
Mr. King, what was your experience last time when you tried to depose him?
Generally setting it up, I believe we could probably do it within 30 days, but I think that would mean case evaluation would have to be, pushed out maybe 60 days.
Okay.
And Judge, can I make a request for my fees and costs and having to redepose these individuals?
Oh, you're not paying for them.
Okay, thank you, Judge.
These are at plaintiff's expense too. Yeah. So we'll say redepose plaintiffs within 30 days. Case eval. Adjourned 60 days. Plaintiff responsible for case eval adjournment fees. And we're talking about redeposing, as you said, is the brother and the mother, was it, Mr. King?
Correct, Judge. It's Sean Boyer, SHAUN BOYER, and Viatrol, VEATROL, Thorpe.
Viatrol, VEATROL, Thorpe, okay.
Yep.
Mhm. All right, so, and this is it. It's, these have to be complied with, Mr. Mattson, to the letter. And, you need to work with Mr. King to get Mr. Boyer's DEP immediately so it can fall within 30 days, and Ms. Thorpe's DEP has to fall within 30 days. There's no exception. If it's not done, I'm granting Mr. Boyer's relief as to was it attendant care and replacement services, or both, or one, Mr. King?
It's both, Judge.
Okay. So, this is it. So there has to be 100% compliance. And you can place that in the order, Mr. King, if plaintiff must fully comply with this order, or the attendant care replacement services claims will be dismissed. 100% compliance, Mr. Mattson.
And Judge, in terms of in terms of my fees and costs and, preparing and taking for these depositions, how does the court want to handle that? Should I submit a statement of fees and costs after the depositions?
Yes, please.
Okay. Okay, and I will enter an order today, Judge?
Yes, please.
Okay. Thank you, Judge.
Thank you.
Your Honor.
Thank you, gentlemen. Okay. Kimberly, should I go off YouTube until we get the next person, or what should I
To
do?
see who this is in the waiting room, so let me. You want to take your video off? Hi, good morning. Hi, this is Kimberly, the court clerk. Can you hear me? Uh-oh, why is this? Oh, she's connected to audio. Hello, good morning. This is Kimberly. Can you let me know what case you're checking in on, please?
Yes, this is on Kaden Harris, case
Okay.
number 1901.
I see it. And who do you represent, please?
I'm Ardiana Kulaj for the plaintiffs.
For the plaintiff. Okay. Let me just put that. I'm going to put some information next to your name.
Sure.
No one else is here on your case yet.
Okay, so we will
I'm going to put you back in the waiting room for just a moment. I'm going to change that like so. Okay, I'll be right back with you.
Okay, thanks.
You're welcome. I don't
Relative,
know why they won't let me talk to people in the waiting room. I think that's so ignorant. I don't know. I mean, how am I